Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled, Can State Court Losers Appeal to the Federal District Court and or sue in the Federal District Court? But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, guys, I would like for you all to hit that like button. And also, if you're new to my channel, hit that subscribe button. And also hit that notification bell so you all can be notified as I'm dropping these powerful videos. So without further ado, guys, let's get to it. Alright, so in this video, we're going to find out whether or not state court losers could use the federal district court as a court of appeal, or can they simply sue after the judgment was rendered, okay, in federal district court. We're going to see if that's true or not, all right? So now, because you have a lot of people on the internet telling you all that you can sue in federal court after you was already a state court loser. So we're going to see if that's the case, okay? So now, we're coming from Rooker versus Fidelity Trust Company, which is one of the cases that takes out so many cases, guys, of state court losers going into these federal district courts trying to file their lawsuits and getting laughed up out the court, okay? How do I know? Because it happened to me. I was once deceived like you guys were deceived. I was deceived in believing that you can actually file a federal lawsuit in the district court. Okay? Yes, I was scammed into believing that just like you guys. But let's continue on. Let's pick this up at the top. Rooker versus Fidelity Trust Company, right? And we're coming from where? The United States Supreme Court. So the United States Supreme Court is what, guys? The United States Supreme Court is the highest court of the land. This case was done back on December 10th, 1923, and it's still putting people cases to bed to this day. All right? So now, let's continue on. Let's pick this up at number 1. It states, where a judgment has been rendered. Okay, so this is the portion right here that they use, right? Or that they're trying to use to make individuals believe that child support orders are not judgments, okay? They want people to believe that it doesn't say judge, it doesn't say order, it says judgment, like a judgment and an order is two different things. Okay, so that's why I did my video, guys, showing you all that a final judgment and a final order are in fact the same thing. If you all haven't watched that video, I will put a link to that video in the description box. So after this video go off, simply, click on the link in the description box and that video will start playing for you all can get more understanding, okay? But let's read it again. It states, where a judgment has been rendered, right? After due hearing by a state trial court with jurisdiction of the subject matter and parties, and affirmed by the state Supreme Court, the only resort under the legislation of Congress for correction of error in deciding questions involving the Constitution is to appeal to the jurisdiction of what? Of this court. Of what court? Of the United States Supreme Court, guys. Okay, so you guys must understand there's rules that must take place after you guys receive a final order in child support that you don't agree with, okay? You just can't simply get mad and say, I'm going to the federal district court and I'm gonna sue you. The moment you do that, they're gonna throw that case out. They're gonna read your documents. They're gonna the clerk of court gonna read it, right? And the clerk of court gonna pass it to its assistant and gonna tell his assistant or his or her assistant to throw your documents in file T. For all you all wondering what file T is, file T means to trash, because that's exactly where it's going to go, because they're going to dismiss your case so fast because they know that that court lacks subject matter jurisdiction to even hear your issue. But let's continue. It states, and let's further prove that, it states what? The district court has no jurisdiction, right, of a suit brought there by the party who was defeated in the state court. This is the ruling from the U.S. Supreme Court, guys, which is the highest court of the land. The U.S. Supreme Court is simply telling you guys that the district court, which are the federal district courts, have no jurisdiction of a suit brought there by the party who was defeated in the state court. But let's continue. Then it states, against what? Against his successful opponent. So when they get a lawsuit against you, the first thing you guys do is get mad, because they won in family court. You guys get mad and say, I'm going to show them, I'm going to sue them in federal court. The moment you go there, they're going to laugh at you, and they're going to deny your lawsuit under Rule 12b1 and 12b6 for failure to state a claim upon which relief can be granted. Why? Because the district court that you filed your documents in has no jurisdiction of a suit. You see? And it's just that simple, guys. But let's continue on. It states, all citizens, I'm right here so you all can know where I'm at, right here. It states, all citizens of the same state to set aside the judgment as void because of errors alleged to have been committed by the state courts in deciding constitutional questions, right? Then it states right here, a judge is not disqualified to sit in a case involving the duties of a corporation under a conventional trust merely because of being one of the executors and trustees to whom shares of stock in corporations holding property under like trust has passed for administrations and disposals under a will. And the appeals court did what? Or the federal Supreme Court did what? It affirmed it. Okay? So, this is the federal Supreme Court ruling, guys. The highest court of the land. And they're not only ruling just to make that ruling to be so. No, it falls in line with what? The Constitution. To further prove that, let's go to Article 4 of the United States Constitution. Let's get better understanding, guys. Let's go to Article 4. Right, so now, as you all can see, we're coming from constitution.congress.gov. Let's pick this up at the very top. We're coming from where? Article 4, Section 1 of the United States Constitution. And it reads, let's highlight it. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved, and the effects thereof. So again, guys, this is dealing with not just the state, it's also dealing with federal government. I'm going to prove that as well. So it's basically stating that each order, each record, each proceeding, after a final judgment is entered in, those orders and documents are backed by what? Full faith and credit of that state. So now, let's say if you was, let's say you had a child support case in California, right? But you decided to move to Washington State. So when you get to Washington State, your child's mom or the agency petitioned that Washington State now adopt the order and start the enforcement. Okay? So Washington State will take that order underneath its full faith and credit and start enforcing that same order against you in Washington State now. Why? Because that order that was written in California is backed by full faith and credit from California to give it to Washington State, and Washington State will start the enforcement procedures on behalf of California. That's how they're moving, guys. But let's continue on. It reads, very top, the Constitution's federalist structure allows each state to maintain its own government. This structure creates a risk that multiple states will exercise their powers over the same issues or disputes, leading to confusion and uncertainty. So remember, guys, I was telling you all in my last video that you will not find a federal law that you can use to debunk the state's issues, the state laws and codes. Why? Because they all work together. They are not in confusion. And what I tell you, a house divided cannot stand. How can two walk together unless they be in agreement? So the state and the federal government are both in agreement with each other, guys. So you will not be able to take your arguments into these federal courts, as we just read in what? In the Rooker-Feldman case. Okay? Rooker versus Fidelity Trust. All right? Why? Because it's all dealing with the Constitution. But they want to run around and say it's unconstitutional. No, they're doing everything according to the Constitution. That's what I've been telling you all from the beginning. But let's continue. Then it states right here, the Constitution's full faith and credit clause mitigates that risk by adjusting the state's interrelationships, guys. Okay? So, they letting everyone be on the same accord. They're making sure everyone is in agreement and walking together in this thing. But let's continue on. It states right here, number 3, it states, the clause requires each state to give full faith and credit to the public acts of every other state, such as other state statutes. The clause also requires states to give full faith and credit to the records and judicial proceedings of every other state, which I was just explaining to you guys about. If you lived in California and you had a child support case, but you moved to Washington State, and then California sent the order up to Washington State, and Washington State started enforcing that order. Why? Because that order is backed by the full faith and credit of the state of California. And it's just that simple, guys. But let's continue. It reads, the Supreme Court's interpretation of the clause has shifted over time. The courts has settled on a doctrinal framework that treats out-of-state court judgments differently from out-of-state laws. Then it states, whereas the modern courts generally require states to give out-of-state judgments conclusive effects, states have more freedom to apply their own laws in their own courts so long as they do not close their courts completely to claims based on other state laws. All right, let's continue on. Let's get to the federal part. It states the clause also authorized Congress to enact general laws that prescribe the manner in which states' acts, records, and proceedings shall be proved and the effect thereof. Congress has invoked this authority several times, such as to require what, guys? To require federal territory courts to apply the same full faith and credit principles as state courts. So again, guys, all my videos are truth, guys. I only come to bring the truth. I'm not here to lie to you all. I've been through this, okay? That's why I'm applying pressure. I've been through this, guys. Okay, so again, let's read it one more time. Federal and territorial courts to apply the same full faith and credit principles as state courts. Why? Because they are in agreement with one another, guys. So the moment you've been a state court loser and you file into the federal district court, they will what? Throw it out because the federal district court does not have subject matter jurisdiction because it's not the place to hear those types of claims. You must take that to the federal Supreme Court. But only how you can get to the federal Supreme Court, you must exercise all of your judicial remedies in the state. Meaning you have to go through each court of the state before you get to the federal Supreme Court. And if you don't do that, which these guys don't do and they can't do because they don't know how to write briefs, they don't know how to win in state court, they can't do anything, so they want a federal court off the deception that make people deceive or be deceived that you can actually win when they can't show proof of no one winning whatsoever, okay? So again, to further prove that, now let's go to the federal statute and code that states the same thing. Let's put it in the bed. So now, as you all can see, we're in fact coming from Cornell Law School, which is my favorite website to come to when I'm looking up federal and state statutes and codes, okay? Because they're always up to date. So if you're all looking for state statute and codes or federal statutes and codes, then, you know, simply go to Cornell Law School. They're always up to date with this information. So now, it reads, 28 United States Code, subsection 1738, which is what, guys? This is a federal code, and it reads, state and territorial statutes and judicial proceedings, full faith and credit. So now we see, just like the Constitution, there's also a federal statute that goes along with it, okay? Or a federal code that goes along with it, you know, in support of the Constitution. But let's read it. It states, the acts of the legislator of any state, territorial possession of the United States, or copies thereof, shall be authenticated by affixing the seal of such state, territorial possession thereto. Then it states, the records and judicial proceedings of any court of any such state, territorial possession, or copies thereof shall be proved or admitted in other courts within the United States and its territories and possessions by the attestation of the clerk and seal of the court annexed. If a seal exists, together with a certificate of a judge of the court that the said attestation is in the proper form, then it states, such acts, records, and judicial proceedings or copies thereof, such authenticated, shall have what, guys? Highlighted in red, the full faith and credit in every court within the United States and its territories and possessions. So that's including what, guys? Federal courts as well, because federal courts are in fact what? In the possession or territories of the United States. All right? They have it covered, guys. So understand, when I'm telling you all this truth is for a reason, because I've been through it. But let's continue. As they have by law or uses in the courts of such state, territories, or possessions from which they are taken. So again, guys, you heard it there, okay? One more time. Highlighted in red, it clearly states, full faith and credit in every court within the United States and its territories and possessions. Federal courts are in the United States, territories, and possessions. State courts are United States, territory, and possessions. So again, guys, that's what I'm going to do for today. Let's get this right wisdom, this right knowledge, and this right understanding. Don't be listening to anybody, guys, to just come on YouTube just lying all the time, guys. Take the truth. Learn from the truth. The truth shall set you free, guys. But look, that's what I'm going to do for today. If you all need my help, hit me up in my email at y'allismagnified@gmail.com. Let's get this right wisdom, this right knowledge, and this right understanding. With that being said, guys, you all be blessed. And I say, shalom.